Welcome to Webber Wentzel Legal Insights. With over 150 years of experience and deep industry knowledge, Webber Wentzel is the leading full-service law firm on the African continent.
Good day and welcome to all of you who are listening in. My name is Johan Olivier. I'm a partner at Webber Wentzel. I specialize in employment law and I will be hosting today's panel discussion, which is related to issues affecting foreign employees or expats working in South Africa. This is a fairly complex subject. It touches on various aspects of immigration law, labor law and tax law. And to help refine and focus our discussion, we'll have a question and answer session, and we'll do it on three distinct topics. The first session will cover whether expat workers fall under South African employment law and various aspects relating to those contracts that you enter into with an expat. In the second session, we'll pose common questions around work visas and the employment contracts. And in the third and final discussion, we will look at restructuring employment contracts for expats working in South Africa. Now, to guide us through, we have a distinguished panel here, and we're joined by three experts. The first one is Andreas Krensel. He's the Chief Executive Officer of IBN Immigration Solutions. That's a company that provides specialist immigration services here in South Africa, also in other African countries. And they serve both multinationals and private individuals. From Webber Wentzel's side, we have Joon Chong. She's a partner in our tax practice and has broad experience in tax issues relating to employment as well. Kirsten Eiser is the other partner. She's a specialist like me in employment law. Welcome to our third session of the Webber Wentzel podcast with IBM Immigration Solutions, where we discuss issues affecting expats working in South Africa. Today we will discuss, the contracts of expats deployed in South Africa, and particularly now with the onset of the lockdown and the COVID-19 pandemic, we need to discuss the restructuring of such contracts if needed. Let's pose our first question to Kirsten. Kirsten, is the South African hosting company legally responsible for bearing the full costs around an expat's assignment to South Africa? How can it be structured?
So this will very much depend on the contract of employment, so what's been agreed between the employee and the company, and also what's been agreed between the local office and the foreign office.
What type of tools do the South African employers have if they want to reduce this financial burden linked to a deployed expat in South Africa? What can they do to lessen that financial burden, particularly now in the current COVID-19 situation?
So a very extreme action would be to terminate that employment relationship. There would have to be grounds for terminating that relationship. So your fair reason, which perhaps in these circumstances could be operational requirements, and they'd also have to then follow the procedure. A less extreme measure that could be followed is to look at reducing certain benefits and allowances. This can be done with agreement, so these are negotiated. A good example of that was with your intra-company transfer visa. You might still have that the employee has certain allowances their country of origin that may not be applicable right now. So they could look at reducing those. That would kind of be your best way of reducing benefits, but it would all have to be done with agreement.
Thank you for that, Kirsten. Then also, what happens, in the current COVID-19 pandemic situation, where, for instance, the visa of an expat is revoked by the government? Is it a legal basis for stopping to pay him or paying him allowances?
So it would definitely depend on the circumstances. One circumstance that we've come across is where the foreign employee was actually in his home country when the visa was cancelled and they were unable to come back, but they've still been rendering services internationally. in those circumstances, they're able to render services and honor the contract. So you wouldn't be able to just terminate allowances, but perhaps some of those allowances aren't applicable anymore. So they don't need their local South African rent paid. And you could look and discuss with them cancelling that. A situation, though, could arise where that employee is overseas, unable to render services in South Africa, which is actually a requirement. For example, you don't necessarily want your CEO to be running the business from overseas. And in that way, it may be argued that because of COVID, there is supervening impossibility of performance. And that's a common law contractual issue. And in those circumstances, it could be argued that the no work, no pay principle applies.
Thank you for that, Kirsten. Andreas, turning to you, what are the immigration-related obligations for the employer when the employment relationship ends?
So the first obligation is really to notify Home Affairs that the employment relationship has ended. How do you do that practically? Basically, you take the exit stamp of the expat or the foreigner who has left South Africa, and you email it at the moment to Home Affairs, and that's following the obligation. Then they're meeting the requirements. And the second one is then you need to keep the records of any foreigner for at least 2 years after the employment relationship has ended. So there are really two major requirements.
Thank you, Andreas. Just related to that, both to you and to Kirsten, a question. What are the immigration obligations on the one side and the labor law implications on the other, when in fact, in respect of a South African hosting entity, divisions are sold or restructured? How does that impact on the expat?
Where there's been restructuring, what must always be kept in mind is that the employment relationship still subsists in South Africa. So the employment law still applies to that expat. And that individual should be treated as would any South African employee. You could have a situation, though, where the restructuring has an impact on the specific type of visa. So there's like a change of employer, and that has an impact. And what you might have to do then, the employer might be forced to terminate the relationship because there's been a transfer, and the employee can't simply just transfer over. And so you'd have to then look at your operational requirements and the specific circumstances.
Yeah, maybe if I can add something to that. So from an immigration perspective, we need to obviously be aware of the fact that in South Africa, all work visas, except for the critical skills for 1 year, but all work visas are issued in the name of or with a specific employer on the work visa. So obviously a change of entity might have consequences for the visa. And there are really three scenarios which have different outcomes. The first scenario is very simple, that somebody buys shares in an existing company. So the shareholding changes, but nothing else changes. And maybe the name is changed later from the same entity. And because the entity hasn't changed, which employs the foreigner, you don't really have to do anything with the visa. It can just continue. The second scenario is really when there's a new legal entity. Okay. And there really we need to look if we have a group structure or not. So if the purchaser wants to transfer the whole business into a new legal entity and it's within the same group, then Home Affairs advised us that you just have to notify Home Affairs, because in the end, within the transferred group or within the transferred company, nothing changes. The foreigners still have the same understudies. The foreigners are still having the same obligation, the same responsibilities. Therefore, nothing really changes in terms of the work visa, the conditions. And then obviously the last scenario is really if you sell a business unit to a completely unrelated purchaser and you bring it into a brand new entity, well, then you need to change the work visa, and that's actually you need to apply for a new work visa. So these are the three scenarios from an immigration perspective.
Thank you. Just to add to that, Kirsten, I would suppose that in such a situation, Section 197 of the Labour Relations Act will apply, and that foreign employee will also have the same rights as a South African employee for a transfer of his employment obligations to the new company.
Yes, Johan, that's correct. So, as I said before, they would have the same rights as any South African employee, and they would then transfer with the business as a going concern.
Thank you, Kirsten. Thank you, Andreas. So let's end off with tax again. Joon, could you explain to us the tax implication on the South African side of, one of these expat assignments, prematurely ending in South Africa, say, for instance, as a result of COVID-19?
If the expat is not a South African tax resident, for example, the expat hasn't stayed in South Africa long enough to meet the physical presence test, or is never intended to relocate to South Africa permanently, then there are no exit taxes, no deemed CGT on any property which is held worldwide. Then it's a question of was there a settlement agreement, settlement amount paid, which could qualify for severance benefit, and that would be the end of it. The expat should update any sort of tax registration details with SARS, and then file the last annual provisional tax and the last annual return, and then update the details of addresses, and that should be the end of it. There's no process to deregister from SARS once you are a taxpayer. It's just a question of updating details and filing nil returns until the system automatically deregisters the person.
Thank you, Joon. Well, that brings these 3 sessions to an end. I'd like to thank Andreas from IBN Immigration Solutions for his contribution, and then Kirsten Eiser and also Joon Chong from Webber Wentzel for sharing their insights, and for our listeners for joining us. If there are any matters on which you need specific advice, please contact us at Webber Wentzel or at IBN Immigration Solutions. This has been a Webber Wentzel Legal Insight podcast. Our executive producer is Paula Johans, and this podcast is produced for Webber Wentzel by Volume. This is Johan Olivier signing off. Thank you for listening.
You have been listening to Webber Wentzel Legal Insights. You can find and subscribe to the podcast on all major platforms. For more expert legal insights and updates, visit webberwentzel.com.